Imagine the classic courtroom drama. You've seen it 100 times on TV.
Oh, yeah.
The music swells. A surprise witness bursts through the double doors. A lawyer is shouting at the jury, slamming their fist on the table, and suddenly pulls out a smoking gun that nobody knew existed. The judge is banging the gavel, shouting, "Order! Order!" It is chaotic, it is emotional, and it is incredibly entertaining.
And it is also, generally speaking, completely fictional. I mean, if that actually happened in a federal court, it would result in a mistrial so fast your head would spin.
That's what we're tackling today. We're deconstructing the myth. Because
Yeah.
the reality of a trial isn't chaos, it's actually more like a very complicated board game.
That's a good way to put it.
Or, to use a better analogy, it's like a computer operating system. It has a very specific, very rigid set of instructions that determine exactly who can speak, when they can speak, and what they're allowed to show the jury.
That is a great way to frame it. The legal system is an operating system. And the code for that system is what we are talking about today, the Federal Rules of Evidence. Specifically, we are looking at presentation and procedures.
This is the deep dive into the mechanics of justice. Our mission today is to take this source material, Federal Rules of Evidence, presentation and procedures, and decode it. We want to understand the gameplay loop of a trial. Whether you are a law student, a writer trying to make your crime thriller realistic, or just someone who wants to know how the sausage is actually made, we're going to break this down into simple, clear English.
And there's a lot of ground to cover. We're going to look at, the division of labor between the judge and the jury, the high-stakes game of objections, and even some weird paradoxes of what you can and cannot prove in a courtroom.
We're going to explain why you can't just ask, "So you're a liar, aren't you?" on the witness stand, at least not whenever you feel like it.
And we are going to talk about bursting bubbles, but we'll definitely get to that later.
All right, let's start at the very beginning. Section 1, the arena. Where do these rules actually apply? I assume we are talking about federal court, given the name.
Right, exactly. So under Rule 1101A, these rules apply to proceedings in United States district courts, courts of appeal, the bankruptcy court, and the claims court. It covers both civil and criminal cases.
So pretty much any federal case that goes to trial.
That's the main idea.
The premise seems simple. It sounds like a manual you'd buy at a government bookstore. But looking at the scope, this isn't just a manual, it's a filter, isn't it? It creates a specific reality inside the courtroom that is distinct from the reality outside of it.
That is the best way to think about it. The courtroom is an artificial environment. In the real world, if you want to know if someone robbed a bank, you'd look at everything. Rumors, hunches, an anonymous tip, a diary entry you found in the trash. You'd take in all the noise.
Right, all the data you could find.
But in a federal court, under Rule 1101, we deliberately shut out the noise. We prioritize reliability over raw information accumulation. We're trying to build a clean, sterile environment for decision-making.
But not always, and this is where the notes get really interesting. The rules apply to the trial, civil or criminal. But there's a whole list of proceedings where the operating system essentially shuts down or goes into safe mode.
Exactly. The rules generally do not apply to grand jury proceedings.
Okay.
They don't apply when a judge is issuing a search warrant or an arrest warrant. They don't apply to bail hearings, sentencing hearings, or probation revocation.
Wait, let's unpack that logic. If I'm at a bail hearing, a judge is deciding if I get to go home or sit in a cell for months. That feels incredibly high stakes. Why are we throwing out the rule book and letting the prosecutor use hearsay or, less reliable evidence to keep me locked up?
It feels counterintuitive, doesn't it? But you have to look at the purpose of the proceeding. A trial has one goal: finality, a judgment of guilt or liability. That bell cannot be unrung. But a bail hearing, that's a temporary measure, a grand jury. That's purely investigatory.
So because it's not the final word, we accept lower quality data.
We accept faster data. Think about a search warrant. If a police officer needs to enter a house because they have a strong suspicion a kidnapping victim is inside, they cannot wait 3 weeks to authenticate a chain of custody for a document or bring in expert witnesses to verify a signature.
Right, time is of the essence.
They need to act on probable cause. If we applied the strict federal rules of evidence to a warrant application, the system would grind to a halt, and evidence, or worse, victims, would disappear. The system trades rigor for speed in those preliminary stages.
Okay, so we have the Wild West of preliminary hearings, and then the clean room of the trial itself. Inside that clean room, we have this fundamental division of labor between the judge and the jury. The text calls the jury the trier of fact and the judge the trier of law.
And this is the separation of powers in the microcosm of the courtroom. It's a really foundational concept.
Trier of fact versus trier of law. Let's break that down for everyone listening.
Sure. The jury's job, and essentially their only job, is to decide what happened. Did the light turn red? Did the defendant sign the contract? Is this witness sweating because they are lying or because the AC is broken? They weigh the credibility. They decide the narrative of history based only on the evidence they're allowed to see.
And the judge?
The judge acts as the gatekeeper. Their job, under Rule 104A, is to decide if a piece of evidence is allowed to be seen by the jury in the first place. That is a question of law. Is it hearsay? Is it relevant? Was it obtained legally?
So the judge decides if we can see it, and the jury decides if they believe it.
Precisely. But the line gets blurry, and this is where it gets a little strange. The notes mention Rule 104A specifically. And here's a paradox that law students really struggle with. In order for the judge to decide if a piece of evidence is admissible, the judge acts as a distinct investigator. And under Rule 104A, when making that specific decision, the judge is not bound by the rules of evidence.
Wait. Pause there. That sounds completely circular. The judge uses inadmissible evidence to decide if other evidence is admissible. How does that work?
It sounds circular, but yes, it's necessary. Let's use a hypothetical. You have a witness. Let's call him Mr. Smith. The defense claims Mr. Smith is actually incompetent. He holds a massive grudge. He's mentally unstable. Maybe he was hallucinating that day. They want his testimony thrown out entirely.
Okay, so the defense says, Judge, don't let the jury hear this guy. He's bonkers.
Right. To decide if Mr. Smith can testify, the judge might need to look at an affidavit from Smith's psychiatrist. Now, normally in a trial, that affidavit is pure hearsay. You can't just wave a piece of paper from a doctor. You have to bring the doctor in to testify under oath.
Right, and be cross-examined.
Exactly. But for this preliminary decision, the judge can just read the paper. The judge can consider all that bad evidence to make the legal determination of whether Mr. Smith is fit to sit in that chair.
Because we trust the judge to compartmentalize, to see the inadmissible stuff, but not let it affect their final judgment on the overall case.
We trust the judge to separate the legal wheat from the factual chaff. We absolutely do not trust the jury to do that.
And that leads directly to this idea of the hearing on admissibility. So if the lawyers are fighting about whether Mr. Smith is crazy or if a confession was coerced by the police, does the jury sit there and watch that fight?
Absolutely not. Rule 104C is very specific about this. If the jury hears the whole argument about the coerced confession and then the judge decides, actually, this was coerced, you all have to ignore it, it's way too late.
You can't unring the bell.
Exactly. The human brain can't just delete a file on command. If I tell you the defendant confessed but ignore that because the cop didn't read him his rights, what's the one thing you're going to remember?
That he confessed.
Of course. The bias is already there. So sensitive legal arguments regarding things like confessions or the admissibility of prior crimes, they almost always happen with the jury out of the room.
It's like a spoiler alert. You can't tell the jury the ending and then tell them to pretend they don't know it while they watch the movie?
That is a perfect analogy. And once the judge admits the evidence, let's say the confession is allowed in, the judge's job regarding that piece of evidence is mostly done. Now it shifts entirely to the jury. The defense can still argue to the jury, hey, he was tired, he was scared, he was pressured, he didn't mean it.
And the jury can decide, yeah, we see the confession, but we think it's garbage. We don't believe it's true.
Correct. The judge said it was legal to admit it. That's admissibility. The jury decides if it is true. That's credibility and weight. Two totally separate functions.
Okay, let's do a quick recap of the basics before we move on. This is Section 1 wrapped up.
Sure, let's do it. 1, these rules apply to federal trials, but usually not to things like grand juries, warrants, or bail hearings where flexibility and speed are needed.
2, the judge is the trier of law, or the gatekeeper. They decide what gets in.
3, the jury is the trier of fact. They decide who and what to believe.
And 4, arguments about sensitive admissibility, like confessions, happen without the jury present to avoid biasing them. You can't unring that bell.
You got it.
Got it. The stage is set. But now the game begins. And in any game, players disagree with the referees. In court, we call that an objection.
Right. This brings us to Section 2, challenging the call. And this is all governed by Rule 103. This is where the courtroom drama gets a little bit real.
This is the part where the lawyer jumps up and yells, objection. But the text says you can't just object for fun. It has to affect a substantial right. What does that even mean?
It means the court system doesn't want to waste time on trivialities. You can't object because a lawyer ended a sentence with a preposition. You fight over things that could actually change the outcome of the case. Now, there are two main scenarios here. Scenario A is when the judge lets evidence in and you want it kept out.
Okay, so the prosecution tries to show a gruesome photo of the crime scene, and I'm the defense lawyer. I don't want the jury to see that.
You have to object immediately. The rule says the objection must be timely.
Like throwing a challenge flag in football. If you wait until the next play starts, you've lost your chance.
Precisely. It's a waiver. If you let the witness answer the question, talk for 5 minutes, and then say, objection, it's too late. The jury has heard it. And this is crucial. You have to state the specific ground. You have to say objection, hearsay, or objection, irrelevant. You can't just say, I don't like this.
So you can't just stand up and shout objection and hope for the best.
No, absolutely not. The rule says you don't need to state the ground if it's apparent from the context, but good lawyers never rely on that. They state the specific rule because it does one critical thing. It preserves the issue for appeal. If you don't object specifically, you generally can't complain about it later to an appeals court.
Okay, that's scenario A. What about scenario B? This one feels trickier to me. The judge keeps evidence out. I want to show the jury an email that proves my client is innocent, and the judge says, no, that's inadmissible. How do I challenge that ruling?
This is a critical danger zone for trial lawyers because of how appeals work. If the evidence is excluded, the jury never sees it. But crucially, the record, the transcript of the trial, doesn't show what that evidence was.
Right. Appeals courts don't retry the case, do they? They just read the transcript.
Exactly. They look at the cold record, and this is the trap. If the judge says objection sustained, you can't show that email, and you just say, okay, Your Honor, and move on, the transcript will simply show that exchange. 6 months later, the appeals court judges are reading that. They have no idea what was in the email. They don't know if it was a smoking gun or a grocery list.
And they can't rule on what they can't see.
They'll look at that blank spot in the record and say, well, we can't overturn the verdict because we don't know if this error even mattered, so you are sunk.
So you have to somehow force the ghost of that evidence into the record.
You have to perform what's called an offer of proof. Rule 103A2, you have to stand up, usually after the jury has been asked to leave the room, and you have to dictate into the record exactly what that evidence would have been.
So I'd say to the court reporter, for the record, Your Honor, if my witness had been allowed to answer, he would have testified that he saw the getaway car and it was green, not blue.
Yes. Or, if I had been allowed to introduce this email, it would have shown that my client was in another state on the day of the crime. You are building a lifeboat for the appeal. Without an offer of proof, the error is harmless because, to the appellate court, it's invisible.
That requires so much presence of mind. You're in the heat of battle, the judge just shut you down, you're probably flustered, but you have to remember to do this specific procedural ritual.
It's one of the hardest things for young lawyers to learn.
So what if you freeze? What if the judge lets in something terrible, like that coerced confession we talked about, and the defense lawyer is just asleep at the wheel and doesn't object? Is that it? Case closed.
This is the nightmare scenario. Generally, the rule is use it or lose it. If you don't object, you waive the right to complain later. The system values finality.
That seems incredibly harsh. If a lawyer is incompetent, the defendant just goes to jail.
Well, you might have a separate claim for ineffective assistance of counsel later, but for this trial, usually yes. But there is a tiny, tiny failsafe. It's called plain error, Rule 103E.
Plain error sounds, well, plain, obvious.
It refers to an error that is so plain to see, so obvious and so damaging that it affects a substantial right and essentially makes the trial a sham. If an error is that bad, the appeals court can step in, even if the lawyer never objected.
So if the error is essentially a miscarriage of justice, the court steps in to save the day.
Yes. But the bar for this is astronomically high. It has to be catastrophic. You can't rely on plain error as a strategy. It is the Hail Mary pass thrown from your own end zone into a hurricane. Appeals courts hate using plain error. They only use it when the integrity of the judicial process itself is at stake.
Got it. One last thing in this section, limited admissibility. Rule 105. This feels like some serious mental gymnastics.
It is. It's asking a lot of the jury. Sometimes evidence is admissible for one very specific reason, but completely inadmissible for another.
Give me an example.
Okay, let's say a witness takes the stand. The opposing lawyer wants to introduce evidence that this witness has a prior conviction for fraud from 5 years ago. Now, generally, you can't use that conviction to prove that because the witness is a bad person, he likely committed the crime currently on trial. That's called propensity evidence, and it's usually banned. You can't say, he did a bad thing then, so I probably did this bad thing now.
Right.
However, you can use that fraud conviction to attack the witness's credibility, to suggest that they are a dishonest person whose testimony right now shouldn't be believed.
So the jury can look at the conviction to decide if the witness is lying on the stand, but they can't use it to decide if they're guilty of the crime.
Exactly. The judge will give what's called a limiting instruction. They will look at the jury and say, ladies and gentlemen, you may consider this evidence of a prior conviction only for the purpose of assessing the witness's character for truthfulness and for no other purpose.
Does that actually work? I mean, can jurors really partition their brains like that? Don't think of a white bear? And now all you can think of is a white bear.
That is the eternal multi-million-dollar question of the legal system, and there's a lot of debate about it. But under the rules, we have to assume they can. We have to presume that jurors follow their instructions. If we didn't, the whole system would collapse into chaos.
All right, moving on to Section 3, context and common sense. I love this part because it deals with things that seem just, obvious but need rules anyway. Let's talk about the completeness rule. Rule 106.
This is the stop cherry-picking rule. It's one of the most intuitive rules, I think. Imagine a contract dispute. One party introduces a single sentence from a long letter that says, I agree to pay you $50,000.
Looks like an admission of debt. Case closed. Seems pretty clear.
But the very next sentence in that letter says, provided you finish the construction of my house by June 1st. And of course, the construction wasn't finished.
So the first lawyer is taking it completely out of context to twist the meaning. It's misleading.
It's fundamentally misleading. So, under Rule 106, if a party introduces part of a writing or recorded statement, the adverse party can compel the introduction of any other part that, in fairness, ought to be considered at the same time.
In fairness. I like that phrasing. So I can immediately jump up and say, Your Honor, under the rule of completeness, counsel needs to read the rest of that paragraph.
Yes. You don't have to wait for your turn on cross-examination. You can fix the misleading context right then and there. But there is a nuance. It doesn't mean you get to read the entire document if it's 100 pages long. You only get to read the parts that explain, qualify, or clarify the portion that was already admitted.
So if the rest of the letter is about the weather or asking about their kids, that stays out.
Correct. It has to be relevant to fixing the context.
Fair enough. Now, let's talk about judicial notice. Rule 201. This is when the court accepts a fact as true without needing any formal proof.
Right. Trials are expensive and long. We don't want to waste the jury's time and the taxpayers' money proving things that everyone already knows are true.
Like, is the sky blue or does gravity exist?
Exactly. But the outline makes a distinction here that is really important for understanding the scope of this rule. Adjudicative facts versus legislative facts. Rule 201 only covers adjudicative facts.
What is the difference between those two?
Think of adjudicative as the who, what, where, when, and how of this specific case. Was the light red at the intersection of 5th and Main? Was December 25th on a Tuesday that year? Those are facts about the adjudication.
Oh.
Legislative facts are much broader. They are the policy facts about how the world works, which judges use to make legal reasoning and interpret statutes.
Give me an example of a legislative fact.
Sure. If a judge is deciding whether to recognize a new spousal privilege, allowing a wife to refuse to testify against her husband, the judge might rely on the general idea that forcing spouses to testify against each other destroys marriages. That's a fact about society. It's a legislative fact. The judge doesn't need to take judicial notice of that. They just use it as part of their reasoning. Rule 201 is strictly for the factual details of the case at hand.
Okay, so for adjudicative facts, the details of the case, the standard is very strict. The fact must be either 1, generally known, or 2, accurately and readily determined.
Yes. Generally known within the trial court's jurisdiction. A judge in New York City can take judicial notice that the subway exists and runs through Manhattan. They don't need a witness from the MTA to come in and prove that.
And accurately and readily determined.
That means you can look it up in a source that can't be reasonably questioned, like a calendar. If a witness says, I saw him on Friday, July 21st, 2007, the judge can pull up a calendar online and say, the court will take judicial notice of the fact that July 21st, 2007 was actually a Saturday. We don't need to call an expert witness from the Naval Observatory to prove the date.
What about the internet? I see this in the notes. The private company website problem. If I'm suing a car manufacturer and their own website says our brakes are the safest in the world, can't the judge take judicial notice of that? It's right there on the screen from the source.
This is a great question. The judge can take notice that the website says that, But the judge absolutely cannot take notice that the statement is true.
Because it's just marketing. It's puffery.
Exactly. It's
Yeah.
puffery. Sources for judicial notice must be sources whose accuracy cannot reasonably be questioned. A government census report? Yes. A published map? Yes. A corporate About Us page? Absolutely not. That is self-serving, unverified data. So you can't just print out a web page and say, Judge, take notice that this is true.
That's a really important distinction. Now, for me, the most mind-bending part of this section is the jury instruction. If the judge takes judicial notice, say, of our fact that July 21st was a Saturday, the jury is told something very different depending on whether it's a civil lawsuit or a murder trial.
This is one of my favorite quirks in the federal rules of evidence. It's so fundamental. In a civil case like a lawsuit over money, if the judge takes judicial notice of a fact, the judge instructs the jury that they must accept that fact as conclusive. It is fact. End of story.
But in a criminal case,
In a criminal case, the judge instructs the jury that they may or may not accept the fact as conclusive.
wait, that seems absurd. It was Saturday. The calendar says so. We all agree. Why on earth are we telling the jury they can pretend it was a Tuesday if they want to?
Because of the Sixth Amendment to the Constitution. The Constitution guarantees a right to a jury trial in all criminal cases, and the courts have interpreted that to mean the jury, and only the jury, has the power to find every single fact necessary to find a defendant guilty.
So it's about power.
It's about power. If the judge orders the jury to accept a fact, even one that seems obvious, the judge is technically stepping into the jury box and casting a vote against the defendant. And even for something as trivial as a calendar date, the system is terrified of the judge usurping the jury's role in a criminal conviction. It's a constitutional firewall.
So we would rather let a jury be completely irrational than let a judge be even slightly authoritarian in a criminal case.
That is the philosophy in a nutshell. It protects the jury's role as the ultimate check on the power of the state.
Okay, recap time for sections 2 and 3. That was a lot.
Let's do it. 1. You must object immediately, timely, and specifically to keep bad evidence out and preserve your rights for an appeal.
2. If evidence is excluded, you have to make an offer of proof to get it on the record so the appeals court can see what was missed. Don't let the record be blank.
3. Plain error is the last-ditch safety net for massive miscarriages of justice you forgot to object to, but you really can't count on it.
4. The completeness rule prevents lawyers from taking quotes and documents out of context to be misleading.
And 5. Judicial notice lets us skip proving obvious facts, like from a calendar or a map. But in criminal cases, the jury technically has the right to reject them because of the Sixth Amendment.
Excellent. Now let's move to section 4. The flow of battle. How the trial actually moves forward.
Right, the actual procedure. The standard order is very logical. The plaintiff or the prosecutor goes first. They have the burden of proof, so they have to build their case first. Then the defendant presents their case. Then the plaintiff or prosecutor gets a chance for rebuttal to respond to what the defense said.
But the judge is the ultimate timekeeper and director here, right?
Yes, Rule 611A gives the judge broad discretion to control the order of witnesses and the presentation of evidence. Their stated goals are to get to the truth effectively, to avoid wasting time, and to protect witnesses from harassment or undue embarrassment.
Can the judge actually get involved in the questioning? Can they ask questions themselves?
They absolutely can. Rule 614 allows the judge to question any witness or even call their own witnesses, though that's much rarer.
That feels risky. If the judge starts grilling my witness, the jury might think, oh, the judge doesn't believe him. He must be lying. The judge's questions carry so much weight.
That is exactly the fear that lawyers have. And it's a valid one. If a judge asks a question that seems biased or signals disbelief, a lawyer can object. But, and this is a courtesy to the court, Rule 614 says you can wait to object until the next opportunity when the jury is not present.
So you don't have to stand up and embarrass the judge in front of the jury.
Right. You don't want to get into a shouting match with the referee while the fans are watching. You wait until halftime in the locker room.
Smart. Now, let's talk about the interrogation itself. Direct examination versus cross-examination.
Direct examination is when you are questioning your own witness. You are the friendly questioner. You are building your story brick by brick. Cross-examination is when you question the other side's witness. You are now the adversary. You are trying to poke holes in their story.
And the scope of that cross-examination is important here.
Very. Under the federal rules, the scope of cross-examination is generally limited to two things: the subject matter of the direct examination and matters affecting the witness's credibility.
So if I call a witness just to testify that they saw a red car speeding away from the scene, The other lawyer can't suddenly start cross-examining them about a totally unrelated bank robbery from 10 years ago.
Exactly. Unless the judge allows it for a very specific reason, you have to stick to the topics that were raised on direct. If you want to ask about the bank robbery, you generally have to call that witness yourself during your own case. This prevents the trial from becoming a chaotic free-for-all. It keeps the narrative focused.
Let's touch on the Fifth Amendment for a moment. We all know a criminal defendant can't be forced to testify against themselves.
Correct. But sometimes a defendant wants to testify, but only about a very specific preliminary issue, like that coerced confession we talked about earlier.
So if the defendant takes the stand just to say, the cop threatened my family to get that confession, does that open the door for the prosecutor to then ask, so where did you hide the murder weapon?
No. And that's a crucial protection. Rule 104-day provides a shield. A defendant can testify on a preliminary matter, like the voluntariness of a confession, without waiving their Fifth Amendment privilege and opening themselves up to cross-examination on the whole crime. It encourages defendants to speak up about procedural rights without having to forfeit their right to silence on the ultimate quotient of guilt.
That's a crucial protection. One last mechanic in this section: motions to strike.
This happens when the lawyer's question was perfectly fine, but the witness's answer was bad.
Can you give an example?
Sure. The lawyer asks, what color was the getaway car? That's a good, simple question. The witness answers, it was blue. And by the way, I know the driver was a known drunk who hates puppies and never pays his taxes.
Whoa, that's uncalled for, and probably all inadmissible character evidence.
Exactly. The lawyer would immediately say, move to strike everything after the word blue. The judge would then instruct the jury to disregard it.
But here's a weird little exam detail from the notes. Only the examining lawyer can move to strike an answer for being unresponsive.
Right. This is a subtle point. If I ask a witness, did you go to the store on Tuesday? And they start talking about their cat, I can say, objection, unresponsive, because they're wasting my time and not answering my question. But if you are the opposing lawyer, you can't object just because the witness is rambling. You can only object if the ramble itself includes something independently inadmissible, like hearsay.
So generally, the examining lawyer owns the question and the flow of the answer.
That's a good way to think about it.
Interesting. Okay. Section 5. The art of the question. This is where TV usually gets it spectacularly wrong. Let's start with leading questions.
A leading question is simply one that suggests the answer. You were at the bar on the night of the 15th, weren't you?
As opposed to, where were you on the night of the 15th?
All right. The first one puts the words in the witness's mouth. The second is open-ended.
And the general rule is, no leading questions on direct examination.
Generally, yes. When it's your own friendly witness, you want them to tell the story in their own words. If you lead them, the jury thinks you were just testifying through a puppet. It looks bad, and it's against Rule 611C. You want the jury to hear the witness's voice, not the lawyer's.
But there are always exceptions.
Always. You can lead on preliminary background stuff. You are John Smith. You work at the factory, correct. We don't need open-ended poetry for that. Also, and this is important, you can lead if the witness is hostile.
What makes a witness hostile?
Let's say you're the prosecutor, and you have to call the defendant's best friend to the stand. He clearly does not want to help you. The court can declare him a hostile witness, which then allows you to treat him as if you were on cross-examination. You can use leading questions to pin him down, even though you were the one who called him.
And on cross-examination, that's when you're questioning the other side's witness.
On cross, leading questions are not only allowed, they're encouraged. You didn't actually see the light, did you? You were looking at your phone at the time of the accident, weren't you? This is how you control a hostile witness. On cross, you want to limit their ability to explain. You want yes or no answers.
So direct equals open questions. Let the witness tell the story. Cross equals leading questions, where the lawyer tells the story and tries to get the witness to agree.
That is the general rule of thumb, absolutely.
Now let's run through the don't do this list of other improper questions. I'll throw them at you. You explain them. First up, compound question.
That's asking two things at once. Did you go to the house and steal the TV? If the witness says no, what does that mean? We don't know which part they're denying. Did they not go to the house? Or did they go to the house but not steal the TV? It creates a messy, ambiguous record. Lawyers have to break it down. Did you go to the house? Did you take the TV? One fact per question.
Next, assumes facts, not in evidence. The classic, of course, is, when did you stop beating your wife?
It's the perfect example of a trap. The question itself assumes you were beating your wife in the first place. If no evidence has been presented to the jury that you ever beat your wife, this question is highly objectionable. You can't just smuggle a fact into a question to trick the witness or prejudice the jury.
What about argumentative question?
You're just a liar, aren't you? Or how can you sit there and say that with a straight face? That's not a question seeking information. It's an argument with the witness. You save that for your closing statement to the jury. The witness stand is for eliciting facts, not for theatrics and debate.
Calls for conclusion or opinion?
This is asking a regular person, a lay witness, to play doctor or psychologist. For instance, asking, how did your mother feel when she heard the news?
They can't know that for sure. They can only say what they saw. She started to cry, or she screamed and threw a plate.
Exactly. They can describe the observable behavior, which is a fact, but they can't diagnose the internal emotional state, which is an opinion, unless they are a qualified expert like a psychologist. A lay witness can say he looked drunk. They can't say he had a blood alcohol level of 0.08.
And finally, repetitive.
Asked and answered. You can't just keep asking the same question over and over again, maybe rephrase slightly, hoping to trip the witness up or get a different answer. It harasses the witness and wastes the court's time.
Okay, recap section 4 and 5.
1. The judge controls the timeline and can question witnesses, but they have to be careful not to appear biased.
2. Cross-examination is generally limited to the scope of what was said in the direct examination, plus credibility.
3. Leading questions, which suggest the answer, are forbidden on direct for the most part, but they are the primary tool used on cross.
4. Other improper questions include compound, argumentative, and assuming facts not in evidence.
And 5. Witnesses are usually sequestered or kept out of the courtroom so they don't hear each other's testimony and conform their stories.
We are in the home stretch now. Section 6. Who has to prove it? Burdens and presumptions? This feels like the engine under the hood of the whole system.
It absolutely is. We talk about the burden of proof, but it's actually two different backpacks that lawyers have to carry throughout a trial.
The burden of production and the burden of persuasion. Let's start with production.
Think of the burden of production as the entry fee to the game. You have to produce enough evidence to make a prima facie case. That just means on its face. You have to put enough evidence forward so that a reasonable jury could possibly side with you.
So if I sue you for negligence because your dog bit me, but I bring 0 witnesses, 0 photos of the bite, and 0 medical records, I haven't met the burden of production.
Right. If you present your whole case and show 0 evidence that my dog bit you or that I was negligent, the judge can issue a directed verdict right then and there. Case over. You lose. You failed to meet the burden of production. You didn't even pay the entry fee to have the jury decide.
But if I pass that low hurdle, if I show the photos and bring in the doctor,
then you face the much heavier burden of persuasion. This is the ultimate standard.
Yeah.
You now have to actually convince the jury that your version of events is the correct one. And this burden never shifts. If you're the plaintiff, it stays with you from the opening statement to the closing argument.
and the standards for how much you have to persuade them vary depending on the case.
Right. In a standard civil case, it's usually preponderance of the evidence.
Which means
More likely than not. Think of it as 50.1%. If the scales of justice are tipped even slightly in your favor, you win.
Then there is clear and convincing evidence.
That's a higher standard used for things like civil fraud or terminating parental rights. It means highly probable. It's a tougher sell to the jury.
And the big one, beyond a reasonable doubt.
The highest standard in our law, reserved for criminal cases only. There is no percentage, but it means the prosecution has to present evidence that leaves you, the juror, almost entirely certain of the defendant's guilt.
Now let's talk about presumptions. This is where we finally get to the bursting bubble theory. I love this visual.
A presumption is a legal shortcut. The law essentially says, if you prove fact A is true, we will automatically assume that fact B is also true, unless someone proves otherwise.
Can you give me the classic example?
The mailbox rule is the one everyone learns in law school. If I prove that I put a properly addressed stamped letter into a U.S. Postal Service mailbox, that's fact A, the law presumes that you received it. That's fact B. I don't have to hire a private investigator to prove you opened it. The presumption does the work for me.
But it's a bubble, a fragile one.
It's a bubble. It holds air until you poke it. This the bursting bubble theory, which is the majority approach in civil cases. If the other side introduces any credible evidence to the contrary, say, you get on the stand and testify, you never got the letter, or mailbox was stolen that week, the bubble bursts.
And then what happens? Does the presumption
Yeah.
just disappear?
Poof. It's gone. It vanishes as if it never existed. Now it's just a regular fact question for the jury. They have to weigh my evidence, I mailed it and have a receipt, against your evidence, you didn't get it and have a police report about the stolen box. The legal shortcut is gone, and the party with the original burden of persuasion has to prove their case the old-fashioned way.
So the presumption just shifts the burden of production.
Yeah.
It forces you to speak up, to burst the bubble, but it doesn't shift the ultimate burden of persuasion.
Exactly right. It forces the opposing party to engage. If you stay silent, the presumption stands and you lose that point. If you speak up with contrary evidence, the presumption vanishes and we fight it out on the facts.
Are there any presumptions that can't be burst?
Yes, those are called conclusive presumptions, and they are really just rules of law disguised as presumptions. For example, in many states, a child under the age of 4 is conclusively presumed to be incapable of forming criminal intent. You can't bring in evidence to prove a 3-year-old was plotting a sophisticated murder. The law just says no. That bubble is made of steel.
Finally, let's talk about spoliation. That's the intentional destruction of evidence.
If you shred relevant documents or wipe a hard drive when you know a lawsuit is coming, the law hits you hard. The judge can instruct the jury that they are allowed to presume that the evidence you destroyed would have been unfavorable to you.
You destroyed it, so it must have been bad for your case.
Exactly. It's a powerful inference. But the party claiming spoliation has to prove the destruction was intentional, that the evidence was relevant, and that they acted with due diligence to try and get it. You can't just claim spoliation because someone cleaned out their inbox during a routine cleanup 6 months before the lawsuit even existed.
That makes sense.
Yeah.
It's a powerful deterrent against cover-ups.
It really is. It protects the integrity of the whole process.
Wow. We have covered a massive amount of ground.
Yeah.
From the judge as gatekeeper to the specific way you have to ask a question, all the way to the bursting bubble of presumptions.
We really have. And I think the big picture takeaway here is that these rules, while they seem technical and sometimes downright weird, are all designed to create a level playing field. They prevent surprise. They ensure that what the jury hears is as reliable as we can make it. It's not just about winning. It's about the integrity of the truth-finding process.
It's the rules of the game that make the game worth playing in the first place.
That's a great way to put it.
I want to leave our listeners with a thought about that bursting bubble. We use presumptions in our daily lives all the time without even thinking about it. We presume someone is angry because they didn't text us back. We presume a product is good because it's expensive. We presume traffic will be bad at 5 p.m.
That's true. We rely on these mental shortcuts to navigate the world.
In court, it takes just one piece of credible contrary evidence to make a legal presumption vanish. The bubble bursts. But in life, when presented with evidence that contradicts one of our personal presumptions, how often do we let the bubble burst? Or do we just patch it up and keep believing our assumptions despite the evidence?
That is a very provocative thought. Critical thinking, in life as in law, really requires being willing to let that bubble burst.
Something to chew on. Thanks for taking this deep dive with us.
A pleasure as always.
See you next time.